Hello again, Paul. Thank you so much for taking the time in this very, very, very busy autumn. It was quite hard to match our schedule, so thank you again. I'm looking forward to find out about your very lengthy work that you have been doing in the field of copyright. And if I can begin with a very open question, maybe we can start with Communia, the organization that you co-founded, and maybe you can take into consideration telling us what do you understand when you say protecting the public domain, and maybe what you understood in 2010 and what you understand now, because I will also make a connection with the nowadays how to say issues, not to say problems. Please, Paul. Thank you.
Okay, thank you, and thank you for having me here. So Communia, Communia sort of was founded. Sort of Communia is the current Communia Association is actually the follow-up of a EU-funded project which we had, and that project started as something where people from different European countries who were all active in the Creative Commons community. Like I was at the time public lead for Creative Commons in the Netherlands, but there were also the Germans and the Greek and the Polish and the Spanish and the Catalan folks. And we had a sort of like Creative Commons was new, and this was a joint research project to understand a little bit better what we were dealing with. So initially this was like EU projects go, like this was a funded project for 3 years, and it was a networking project, and it really built a community of people who cared about openness and access to information. And this is 20 years ago, right? Like this is almost 20 years ago. This is when a lot of people felt like that the internet had a lot of potential for enabling access to information, but some of that potential wasn't realized, right? Like this is before you had music subscription services, before you could stream pretty much the entire day, or movies. Like it was really in the point where a lot of this was still a bit of a fight, right? Like young people wanted to have access to information online, wanted to listen to music online. And that was the environment that we operated in. And sort of like this served as people from across Europe coming together and trying to sort of together understand what we care about. And what we care about is this idea that is the public domain, that there is sort of information that isn't owned by anyone, that is available for everyone, and that this is fundamentally something that is very important for society, that sort of free access to information exists, either because the information is very old and not protected by copyright anymore, or because information is sort of pure information, not really creative expression, so it's not protected by copyright. Or also, and this is also in our conception, because people choose to share it under Creative Commons licenses, things like Wikipedia, right? Like, so Creative Commons or Communia had this broad conception of the public domain that says like it's important to have free access to as much information as possible. And most of the discussions about access to information in the EU, but pretty much every other part of the world, are always filtered through the lens of copyright. Right? Like, and we know that on the side of in discussions about copyright, you generally have lots of organizations, lots of groups of organizations that represent the interests of particular types of creators or particular parts of the creative industry or particular sorts of rights holders, and they engage in discussions about copyright policy, which is also public domain policy, right? Like, because it tries to seek to put this boundary between what is protected by copyright and what is not. And that there was really very few people, mostly academics, I would say at that point, like who were understanding the importance and the value of the public domain. And so Communia was then, after that project had ended and we had spent those 3 years with the EU money traveling to many conferences and writing papers and writing a book and sort of like building a pretty strong network, we actually used part of the funding to set up an international association under Belgian law that is the Communia Association that still exists today, that has very decidedly the mission to sort of fight for, or I don't, fight is the wrong word, right? Advocate for the interests of the public domain and access to information, mainly active in Brussels. That's also why we set it up as a Belgian association, because a lot of these policies are made on the European Union level at the moment, but Communia is also active in the context of WIPO. It's the World Intellectual Property Organization in Geneva. And sort of we've been existing for, I don't even know, like 12, 13 years, maybe, certainly more than 10. We have sort of like the core guiding principles is something that we published in I think 2009, the public domain Manifesto. And we also had a set of policy recommendations, which we made around that time. And there's an updated set of policy recommendations that we issued like 2 years ago. And sort of over the years, Communia has been a sort of frequent and I think also respected participant in discussions about copyright policy in Brussels. And that's what we do.
Thank you so much. It's good to know, because I think the verb fight can still hold its place, because actually what I have been noticing is that the copyright umbrella takes different shapes depending on the year we are in, depending on what level, and national level, EU level, and now with AI. But I will leave AI just a bit aside. I myself am very interested as well in copyright, and I have already, I have been making a little study about the copyright directive, the European Union one.
Yeah.
But I would like to invite you to say a bit about the process that led to that copyright directive, and the process you were involved in. Maybe you can mention a bit about Europeana, if you want, in this context, or aside, and maybe to put a focus on Article 17. But I will leave you with that to explain, please.
Okay, I'll try to do my best. This is a very long and complex thing, right? Like I think most people will remember the copyright directive, which was one of the sort of certainly most controversial and long-running legislative processes in Brussels in the digital rights field, broadly speaking, that roughly took place between 2014 and 2019. Like 2014, it was announced. 2016, the Commission made the proposal that sort of like proposed the text, and then between 2016 and 2019, the Parliament and the Commission and the member states negotiated, and it was finally adopted in 2019. You could say it was even longer, because there's also it was immediately or parts of it were immediately challenged by the government of Poland right when it was adopted. So like there was actually like a court case that took almost another 2 years to resolve in the Court of Justice. So like this whole process of getting this copyright directive adopted and getting legal clarity about it took more than 5 years, 6.5 years, I think. And that doesn't even take into account all the discussions before. And many people like sort of like, I think now everybody calls it the copyright directive or the DSM directive. We used to call it copyright reform in that time, because it was an attempt by the European Commission realizing, or many people realizing, that sort of like the increasing amount of digitization had sort of like required copyright to be updated in a number of things, in a number of aspects. And people's opinions widely disagreed what this should be, like the update. But like it was clear that there needed to be something done. The old rules were from 2001, very early in the era of online access and online circulation of cultural goods. And by that time, 2014, it was clear that something needed to change. Then what happened is it was a sort of like a very broad set of very different issues packaged into one legislative proposal. To give you an example, like the thing in copyright policy before was the Orphan Works Directive that dealt with one tiny little thing, one issue, like what do you do with orphan works? The Copyright Directive has about, I don't know, like more than 15 different issues that it deals with, right? Like, and they range from things that concern the relationship between creators and then distributors or publishers or further distributors of their works, like which is often sort of referred to as contractual agreements in the copyright field. They range to things dealing with access to out-of-commerce works. There are things in there that are about the protection of the public domain. There are things in there that sort of deal with a number of key exceptions and limitations related to teaching, related to access to cultural heritage, related to text and data mining. I guess we come back to that in the when we talk about AI. And then there were two super controversial parts of it. Like one was the Article 17. For the longest time, it was actually called Article 13, while it was discussed like this 17 is the numbering after the directive was agreed upon. But that was generally sort of on the one side referred to as a provision to close the value gap. That was from the perspective of the rights holders. And from our perspective, or I think from the perspective of Communia and many others working in the digital rights field, it was called like the upload filter provision. I'll come back to that. And then there's another thing which was also very controversial, not as controversial as Article 13, which was called, which is a press publisher's right, a new neighboring right for press publishers. Sort of that was sort of referred to by many people critical of this, including us, as a sort of link tax. And for others, it was mainly from the rights holder side, it was seen as sort of like something that was very important to preserve the position, the economic interests of publishers of press publication. The weird thing about the thing is that sort of at the time when this was discussed, there was a very clear hierarchy. Like Article 13 dominated, so 13 later 17 dominated the discussion, and then there was the press publishers right, and then for a long time nothing came. And then sort of like there were some smaller discussion, like some smaller things, but the discussion was really, and this had two effects, right? Like this entire thing became known as this thing about the upload filters and the press publication, and that was where like there was really sort of very big sort of like, I think it's correct in this case to say fight, right? Like this were like really groups like they're saying like, okay, this is, people on our side were saying, if this gets adopted, it's the end of the internet. And the rights holders were saying like, if this doesn't get adopted, it's the end of the creative industries in Europe, right? Like it's sort of like truth is like in hindsight from now, no, it was neither, right? Like it actually turned out to be much less consequential than everybody made it to be. But this also led to another thing that, if you will, in the shadows of these big sort of like two sides or sometimes three sides discussions, there was some productive stuff which got done on other parts. Like one example is that there's actually provision, like the provisions around access to out-of-commerce works, which were relatively narrow in the original Commission proposal. It was just a sort of like licensing-based approach, got quite substantially expanded into something that also says like, okay, and if licensing doesn't work, then there is an exception that allows institutions to make available works, which was something that was not easy to get done, but it was not something that people, organizations were fighting about in public, right? Like it was, yeah, we have a problem here. It was disagreement about the best approach, and then sort of like a compromise was found. And I think something similar happened sort of around, for example, the text and data mining exceptions, which were also somewhat narrower in the original Commission proposal and have been expanded in the final version. Again, this was the outcome of constructive discussions at that time, which we'll come back to that. But interestingly, also, I think a lot of people thought the Article 13 thing and the Article 17 thing is super important and didn't pay a lot of attention to this thing. Like, right? Like it was sometimes in this thing where like the main fight was somewhere else, some of the smaller things could be resolved. And in the end, sort of all of like in the end, this hinged on the decision if this should be adopted or not, this directive was in the end by, it depends a little bit on how you count, because there were some votes where people said they voted not, but like this was very narrow. It was probably 4 votes of difference that we would not have had this. But this was essentially about like either you take the entire package or you don't take it. And in the end, it was adopted. And the article and this decision to adopt or not to adopt almost entirely hinged on Article 17. And that was this idea that so the issue at stake there is, the question was that before Article 17, sort of user upload platforms, user-generated content platforms, the example that everybody talked about and what this is mainly about has always been YouTube, is the question, who is responsible for copyright infringing uploads to something like YouTube. The pre-copyright directive situation was the platform itself is not directly responsible, because it is not the platform which makes it available, it's the user who uploads it, right? Like, and so there was a situation where the platform, as long as it would honor takedown requests, so if something illegal was uploaded and sort of rights holder would come and say, please take that down. If they took it down, it wasn't, then the platform had no responsibility. That makes a lot of sense if you look at the situation where you think like, okay, who's actually doing the uploading? Like, but many rights holders said like this allows the platforms to like build business models on this, create lots of sell ads, and essentially take no responsibility for this. And so they pushed for something where they should be made responsibility. In the end, what Article 17 sort of introduces is sort of some qualify, and so that would have been and the argument of those opposing this approach was, if you make the platforms responsible for each and every user upload, that will have a very sort of stringent ramifications on the ability what platforms will allow to upload, because they need to be on the safe side and they will filter lots of stuff out, and this will essentially result in a situation where they will reject a lot of stuff where the legal status is unclear, and so it's a limitation of users' freedom of speech, if you will, or freedom of expression. What came out of it is quite a complicated compromise, which comes in. There is an obligation to make best efforts to ensure that things are removed, that things are not uploaded if they are clearly infringing, but because it is also many uses under copyright exceptions, right? Like, they are extremely context dependent. If something is a parody of something or not, it's largely, you can't tell that based on that thing alone. You can only tell that based on the context, how it is presented, etc. This is also something which even now, like, machines are really, really bad at understanding this. They're good at saying like, this is the same thing as this, or this is a very similar thing as this by now, but like they are still not very good at saying like, okay, this is a parody or it's not a parody. And so the compromise, in the end, it was a compromise. In the end, it didn't sort of, it didn't move the needle very far. Like, I think importantly, I would say that Article 17 is actually sort of a win for users' rights, because it positively says like that these things are worth the freedom of expression, the ability to engage in things like parody, critique, citations are positive rights that need to be protected, and they are. In the end, now we're like 6 years after the adoption of the copyright directive, and Article 17 really doesn't interest very many people. I don't think it changed a lot. I think like in the end, the the main thing which made it go away is probably because especially YouTube, but also other user-generated content platforms have managed to find sort of like to fine-tune their business models in a way that that it is clear to almost all rights holders that they benefit from the existence of these platforms, right? Like, so there's financial arrangements in place. And in the end, that fight from this distance looks a little bit overblown. And it is a bit ironic to some degree that sort of like while the entire fight about the copyright directive was mainly about Article 13, what seems to have been the most consequential sort of part of the copyright directive has been something that got relatively comparatively little, right? Like there were hundreds of lobbyists and hundreds of lawmakers and hundreds of people making sense. Like everything, like every letter got scrutinized by this, but compared to the other things, got relatively little attention, which are these two exceptions for text and data mining. Because if you move forward to around 2021, 2022, it suddenly became evident that these were sort of like crucial additions to the EU copyright law that deal with questions that suddenly bubbled up around the relationship between copyright and generative AI training, mainly.
Yeah, thank you very much, because yeah, this popped up even now, the famous Article 17, which I didn't know it was 13. But before we move on, are there any art, because you pinpoint that it was such a fuss around this, and some others stayed in the shadow. Looking retrospectively, in a retrospective, do you think there are one or two points that needed to be addressed and it didn't, and now you can see some unfortunate results out of it, or not necessarily?
So I think the biggest thing that it should have addressed and it didn't address is sort of actually a much further harmonization. For people not that familiar with copyright, like copyright in the first place is national law, and the EU directives try to give instructions to each and every member state in their own copyright law to do things in a specific way. The 2001 had on the sides of these user rights, so exceptions like the right to parody or the right to quote or the right to use something in an educational setting. They had a long list of 17 or so exceptions, and they are optional, most of them, except one. And they said sort of member states can implement these, but they don't have to. Which leads to a situation that is still the case in Europe, that sort of like something that you can do in one country, you may not be allowed to do in another one. I think the best example for this is an exception called, often referred to as a freedom of panorama exception. So in some member states, it's perfectly fine to take a photo of a artwork that is displayed in public view, in public space, and in others it isn't. So in sort of like you can, in some countries you can take a photo of like an artwork and say like, okay, like you publish this on your weblog, and that's fine because like this was a publicly accessible artwork taken photo from a public space. In other countries, this is not the case. The famous example for this is always taking an Eiffel Tower, a photo of the Eiffel Tower at night. In France is copyright infringement because the lights of the Eiffel Tower are a artwork under copyright, and that is still in copyright, and so you need permission to actually publish this. And this exists for a number of things in thing. And so the copyright directive, the 2019 one, harmonizes like the new exceptions that it introduces, like the TDM exception or like the exception for access to out-of-commerce works, they are mandatory in all member states. So they need to be implemented by each member state. But a lot of the rest of the copyright legislation is still very different. So that's probably the biggest shortcoming of the copyright directive in that sense. We had other things that we would have liked to see in there, but I think you also like you need to find support for these things, and like in the end, like there's quite a lot of good stuff in there. Most of these exceptions. What's also really good is this protection of the public domain provision, the access to out-of-commerce works, the provisions that sort of improve the contractual relationship and transparency position of creators vis-a-vis sort of subsequent right holders are very important. So all in all, it is. I think it was this real step forward. The main problem being like that it still sticks to this sort of like territorial approach, right? Like we see lots of other things. For example, the AI Act is a regulation, an act that applies the same way in each and every member state. And for lots of historical reasons, like many member states see copyright as like really like a cultural sort of like a cultural policy, and there's no there's no real justification for letting the EU make cultural policy that's often considered to be a member state privilege, and therefore it stays in this fragmented thing. But as copyright deals increasingly with sort of like forms of use, be that YouTube or be that now the AI models or be that any online services essentially that operate on the level of the entire European Union, this fragmented approach just makes less and less sense.
Actually, if it's a directive, it should be compulsory. That's why it's a directive. Otherwise, you would make it I don't know, a resolution, then that would be it. So
Yeah.
yeah.
It is to some degree, like I think there's very, very different traditions between member states, how they think about copyright, right? Like in the sort of probably on the one end of the spectrum, it is a country like France where culture and the protection of culture, and therefore in their perspective, the protection of copyright is almost like one of the core functions of the state, right? Like that's part of the national identity. And on the other hand, like there's member states, it's hard to give a specific example that is as clear cut as French, but like generally, if you look to sort of like the Baltic states of Finland, where copyright is considered to be like an like an economic instrument mainly, right? Like that is sort of like you there's a creative economy, and like you need some measures to steer that. These are conceptually very different ways of cooking that. And so like I think the reluctance of the member states to actually accept sort of like more harmonization there is because it is really like it goes to the identity or like the national identity of a lot of things. And traditionally, that is something that we've tried to stay out of. Sort of like the idea of the European Union is the European Union deals with the things that are sort of like that make sense to be dealt with at the European level because of the single market, because of the fundamental freedoms in the EU. And it stays away from those things where it doesn't have to intervene. And I think like the copyright is increasingly at a fairly untenable space in the middle where from a sort of cultural national identity, it doesn't belong there, but from a economic reality, it does.
We shouldn't mess up with identity. Look what happens nowadays. Yeah, you mentioned, among others, responsibility, of course, a dear word to us all. But starting with this, we can jump to the AI and the data mining. Because you also have this year you published a white paper, a possible proposal what to do when AI is trained with public domain information, but also artworks, etc., that holds a copyright. So maybe you can tell us a bit about what you propose, and if you think it can. No, I want to rephrase. Where do you think your proposal can fit in? It can be, I don't know, in a kind of directive, talking in an ideal world, to be put in a copyright directive, to be slided to the AI Act, to be I don't know, to give it to those institutions that deal with the copyrights. In Romanian organisme de gestionare colectivă. So actually, how did you arrive to that proposal, and how do you think you can push it along?
Okay, maybe go back how I arrived at the proposal. So first of all, and this goes back to the TDM exceptions in the copyright directive. So 3 years ago, like a bit more than 3 years ago, it becomes evident that there is a new form of using cultural content, right? Like this is in the summer, you had sort of like these first sort of like image generation models, like stable diffusion. And then I think pretty much not exactly, but around this time, 3 years ago, ChatGPT was published, right? Like, and it just relatively quickly became clear that this is sort of these things can do because they have been trained on gigantic amounts of works, that be then texts in the case of ChatGPT or images in the case of Stability AI. It was also pretty clear that nobody had asked for permission for this, and like that included lots of like copyright things. And that raises lots of questions about copyright, like, and sort of we sort of like, I think at Open Future were one of the first ones to point out that in the EU, the text and data mining exceptions actually pretty accurately describe like this idea of text and data mining, which is said like which is essentially like the computational analysis of huge amounts of protected works in order to extract patterns and correlations and things like that. That this is essentially what happens at the AI training stage, right? Like they take lots of text or lots of images and try to understand like how elements of that relate, which word or which token follows which one, how sentences are constructed, like how sort of like if you have specific elements in an image, like how what comes around it. It's all prediction based on being exposed to large amounts of that and pattern learning and then sort of deploying these patterns. And so we said like, hey, so maybe we and this the initial, like the copyright is in principle a pretty black and white system. Like either you can do something because it isn't an infringement of copyright, or you cannot do it, and then you need permission of rights holders. Now the question with this it was also clear it was all trained on everything on the internet and sort of like be that copyright protected or not. A lot of that stuff nobody cares. Right? Like nobody would even care to give permission when asked. So if you would say like you need explicit permission from every single rights holder for everything that you use to train an AI model, you set this up for failure, because there's no way in the world that sort of every single rights holder, and this is about billions of work, right? Like that can be found, that will give you like that would even answer the email or whatever you sent them in order to ask for permission. You can't also send 5 billion emails, is also not possible. So but it was also clear that there are a lot of people sort of like who said like, hey, this, I don't like this, because if you train on my material, then sort of like that, and that was pretty evident pretty soon, this will allow these models to produce things that either look exactly like mine or very close to it, or at least even if say they compete with my products in the broader market, right? Like, so we had, I think, legitimate interest of sort of like these companies and researchers developing these AI models and rights holders to both say like, okay, we need, on the one hand, we need access to as much as possible, and on the other hand, saying like, we want to have a say in how far our stuff is used. And then if you look at the text and data mining exception, there's two of them, right? Like the TDM3 exception, which is for scientific research purposes. That is fairly limited to who can make use of it, which is scientific research organizations and cultural heritage institutions. It's clear that the big companies who train AI models are not among the beneficiaries. So then you end up with Article 4, which does the same, but has this very interesting thing, which says you can do text and data mining on everything that you have lawful access to, so things that you find on the public internet, except when the rights holders have said no, have made an opt-out in a machine-readable way. So we said like this is actually like, so we said like this is actually like a very good framework because it sort of balances these things. It allows people who want to exercise their rights to flag that. And for everything else, where sort of like there are no incentives for people to exercise their rights or where the rights holders have gone, like this can be used. And so on paper, the EU framework looks like it can deal very well with this. Now, in practice, it has turned out it can't. There's still no generally accepted way of saying no. Like this needs to have some machine readable standard that says like, I reserve my right for text and data mining, or I don't want this to be trained forever. Shouldn't be that difficult, but try to get people agree on a standard that's at the moment like that looks very unlikely to happen soon. The other thing is that it also turns out that, remember when I talked about copyright being territorial? Copyright law applies sort of in the country, like the EU copyright law does not apply to models that are trained outside of the EU, at least the copyright law pure. Like the AI Act tries to make a difference in there, like that's still somewhat disputed. We will need to see that in practice. But at the moment, like, well, in theory, AI providers have the ability to train in Europe based on these exceptions. And in theory, rights holders have the ability to say no via these sort of machine readable opt-outs. Neither really provides clarity at the moment. The reality is that most AI training therefore takes place in other parts of the world. And that sort of creates a situation where nobody benefits, not the European rights holders, because sort of like they they cannot sort of like get licensing deals, not European AI companies, because they need to work with this legal framework, which lacks sort of key elements for its implementation. If it benefits anyone, it is AI companies who are not in Europe or who can operate outside of Europe, right? Like, so the big existing AI companies, for them, this is relatively straightforward. It keeps the European competition away, which also means that it is completely this situation that we're in goes completely against what the Commission wants at the moment. The European Commission, the big story is Europe must build more AI. Europe must become an AI continent. AI is Europe's future, except our legal regime is not really set up to do that, right? And that brings me to, and sort of we've for a very long time we said like we've got a good system here on paper. We just need to make sure that it functions in practice. I think if you're honest, like we underestimated that sort of like that just like what it means to just make something work in practice, because it is extremely difficult and long process and hasn't led to any real workable outcomes. So this and while I personally and our organization and organizations that we work with still is committed to trying to find solutions for making the existing system work, because it will not go away. You can't just change the law in like 3 days. Last time, as we discussed, that takes 5 years or something, right? Like, so we need to deal to some degree with the existing situation. Um, that white paper that you mentioned essentially also says it is unlikely that would, like the current system will really help, and we need to think about alternatives. And I think, at least from a copyright perspective, the main argument that the white paper makes is this idea that we somehow can one-on-one, work for work, or collection for collection can control what happens when these things are used for training is unrealistic, right? Like, a sort of a lot of this stuff has already been used for training, and B, it's so big and so diverse and so complex that this is just doesn't look like a good solution. That's the classical copyright thing you look for. When does something happen? Or somebody takes it, makes a copy, uses it for training, there should be some copyright. But in practice, it's very hard to realize this. So what the paper says is, then maybe we think differently and think about where's the value created when these AI models are where does the value creation take place in this AI economy? And the most likely point, I mean, it's very early, right? Like, the business models are not fully developed. A lot of this is happening at the moment without creating any substantial revenues, or like at least profits. But the value is created when products that include trained AI models are put on the market, right? Like, so ChatGPT is the GPT-5 is the model, ChatGPT is the product. People pay for ChatGPT. Lots of people pay for things that sort of like that were Google products that include AI. Lots of things, like a lot of software as a service things, include AI models at this stage. That's where transactions take place. And then you say, like, okay, then let's acknowledge the fact that all of this has been trained on all kinds of stuff, public domain, publicly available, in copyright, like basically everything that exists in digital form. And just say, like, okay, if you put something on the market that that includes AI that has been trained on publicly available information, then you need to pay a levy, or you could also argue it should be a tax. Like, you pay something that is a proportion of your revenue, or maybe it's a fee per user or whatever. Like, all of this is still very much to be sort of analyzed and to be sort of like better understood. But at the moment where value is created, something needs to be distributed back to the people who produce this content, or the people who steward this content. Like, we're also arguing, we're saying this should not only go to creators, this should also go to organizations, for example, libraries who maintain this information, who steward this, or it should go to organizations like Wikimedia, who sort of create these things without an expectation of direct financial return, but like still they have costs by all the AI bots crawling their things. And so this is what we're proposing that would enable that, sort of, for example, European companies could sort of like train on also the public internet on everything without sort of having all these uncertainties about how sort of in how far this is okay under copyright or not. It would have the ability to sort of like say, like, as long as you're doing research and development, as long as you're doing experiment, like, you are relatively free from constraints derived from copyright. But at the moment where you put a commercial product on the market, then you have to sort of pay. It sort of like favors research and innovation in Europe. It sort of like and says, like, okay, let's make the point of sort of, let's introduce economic fairness to some degree at the point where value is actually created. Um, and that is a proposal, right? It has some precedence in sort of like the copyright sector. Oftentimes when sort of like there's very diffuse forms of use which are not so easy to control. Um, this sort of like more, instead of like allowing every copyright holder to say no, it's often transformed into what's called a remuneration right. So you don't get to say no anymore, but if somebody uses your stuff, like, you are entitled to a remuneration. That's, for example, how the ability of radio stations to play every song works. Like, they can't say, like, no, you can't play this on the radio, but if you play it on the radio, like, you need to pay. Or like, from my childhood, my youth, we had this blank cassette tapes, and we would tape things from the radio, right? Like the top 40 every Saturday, and we would make tapes, and then we would play them the entire week, and trade these tapes with our friends and things. Obviously, these were copies, and obviously these were, like, to some degree, you can argue this was lost income for the musicians making these things, and so how that was dealt with is a private copying levy that if you bought an empty tape, there was a bit of money that went to sort of like the collective management organizations that you described here. And that was then distributed among all of them. That is, by the way, still this private copying system still exists. Like at the moment, in most EU member states, you largely pay if you, for example, buy a new mobile phone, you're paying a few euros for a contribution to this, and that then get distributed by creators. Um, Things like that sort of like enable things to happen and sort of introduce some economic fairness into the system that is badly needed because we don't want an information ecosystem where those who create information reap no benefits from that. And the only ones who extract the value from the system are these intermediaries who provide platforms or AI systems or sell mobile phones or something. Like there needs to be some redistribution to information providers. Otherwise, the incentives to produce information, to create culture will go away. And I don't think any of us wants this. Also, like not even the AI companies need this because they need new input, right? So yeah. And I think you had the question, sorry, I'm talking, giving very long answers, but there was one part of your question, which was, how do you see this happening? Right? Like, is this a directive or something? It's a bit hard to tell. Like this is sort of like a new idea that we introduced sort of like last summer. We are getting a lot of like very interesting feedback from very various sides of the discussion. Um, I could imagine looking back at the copyright directive, right? Like a couple of people say like, okay, we need to change the copyright rules. We need to go back to the copyright directive. We need to sort of either make clear that Article 4 wasn't intended for AI, or we need to make it more workable or something. If experience tells us anything, like this is a process, even from the moment where this decision would be taken to do this, which hasn't been taken by anyone, at least by anyone who can decide this, and this is only the European Commission. Um, it would take a couple of years to do this. So, like, so you go back and try to change copyright in order to fix what is a very unfair system at the moment, like you're 5, 6 years from now. Um, that doesn't seem a good approach to me. You could imagine sort of like that this becomes something which exists on a layer on top of it, like, right, like you don't change the copyright directive. You just have something which introduces a sort of this redistribution mechanism, be that a levy or maybe as a tax, but like I think it's easier as a levy because there's precedence and sort of like direct taxation by the European Union is sort of difficult territory. Plus, like if you look to the current American administration, like if you would put a tax, like explicitly say we're going to tax the big American AI companies, like the reaction would probably not be constructive. Um, but but an instrument which basically says like, okay, we see that in order to enable this system to function and both enable the creation of AI, but also ensure that creators are and other information producers are remunerated, let's introduce a levy system that sits on top of the copyright thing. Right? That is maybe something also if you keep it specific, that can be introduced a lot quicker. Like I think it should also be introduced as something that operates on the European level, so as a regulation, not as a directive, because regulations at least have the advantage that they apply directly. In the case of a directive, you would need to like then the member states need to implement that. That always costs at least another year, oftentimes 2 or 3 years. So generally, this we will probably need to see to some degree. Like there's a lot of evaluation going on at the moment. It seems to be clear to me that something needs to change. But there's ongoing studies or something, so this will still take a while. We appreciate being able to talk here and in other places about this, and um, also like I mean, there might be other proposals to fix this. My conviction more and more, also looking at how some of the court cases that started to appear mainly outside of Europe around this question of AI and copyright have started to develop. Seeing that copyright seems copyright pure and simple as an exclusive right where you can say no to this thing does not seem to be the right tool in order to create any sort of order, in order to create economic justice in this sort of like AI economy.
Thank you. It was not a long answer because I put two questions in one. So yeah, this is the case with these platforms and also the social media being like global, and you can train AI globally in a global pool of data, but you want to regulate it in a certain administrative territory, which is crazy. I mean, the AI doesn't care if this is the border of Romania and Bulgaria. So, so this is a bit.
No, it's very interesting. Like there's this just 2 days ago, right? Like one of the first cases that was filed by copyright holders in response to this new wave. Like this was a case by Getty Images, the photo stock agency, against Stability AI in the UK, who said like, hey, you infringed our copyright because it's pretty clear that you trained on our images to make your model. And they were even capable, you may remember that, listeners may remember that, like the examples that they gave was that Stability AI not only produced things which looked like Getty Images, it also had this watermark of Getty Image in there. Right? Like, so I think on a sort of normal level, like everybody would say, yes, yeah, it looks like they took something from Getty Image, they put it into their system, and their system puts something that looks like something from Getty Image out. That instinctively, like probably to most people who are not like super specialized copyright lawyers, this feel like, yes, they have done some copying. Did they ask for permission? No, they didn't. So probably they did something wrong. This court case sort of was filed in 2023, like it was decided this year. Actually, even Getty had to say like, no, nothing wrong here. They actually retracted that part of their claim because they could not, like, it was clear that the things were not trained in the United Kingdom. Right? Like this was a case in the United Kingdom, and copyright law in the United Kingdom applies in the United Kingdom. So if you take some images from Getty Images and sort of like go somewhere else, which is not the United Kingdom, and you do whatever you want with them, like which might or may not be infringing to copyright under UK law, it doesn't really matter because UK law doesn't apply there. And what you say, like, right, like these are not only gigantic global companies, it's also all of these AI models, right? Like they circulate on the global information on the internet, right? Like which is also global. Like everything is global except the regulatory framework, and often also, and I think that is a bit of part of the problem, if you're honest, the way sort of like on the one hand, these are global corporations, on the other hand, these are sort of rights holders, creators who organize them on the national level, right? Like, and then they're all relatively, I mean, even all of the organized writers or visual artists of in any EU country, even in the bigger ones, like if they band together, are still comparatively small as an organization to sort of like something like Google or Microsoft or OpenAI, and so that is an imbalance and sort of that will not hold, right? Like to some degree, copyright has real limits as a system that is super territorial, that many of these sort of underlying mechanisms that power copyright have been sort of developed in response to technologies like printing books, like creating phono records that were physical in nature, right? Like that they were easy to control, and you could pin them down in the ground and say like, okay, you have this book here in this country, like you shall comply with our laws here. That's just not the case anymore.
Yeah, anyway, before AI taking this huge part of our attention. It was this thing that you can put things together. I mean, basically anyone who has access to the internet can become a producer, actually meaning, I mean, content producer. They can take bits and bits, they make a collage. Look, I use a normal term, and then it's theirs. So actually, this already happened, but this at the AI level, it's like huge billions of big data, and as you mentioned, it's a means of revenue. So there is the difference. Otherwise, a guy is just feeling creative, feeling lucky and creative, and that's it. But on this level, it's quite mission based. I mean, you put together everything, and then you pop up with a huge with a big business. So to make it clear, yeah. Thank you so much, Paul. Thank you. It's actually it's a good discussion. It's a good discussion among other discussions, and hopefully all this discussion in the public space, virtual public space, will maybe not end up in a resolution or in another form of legislative piece, but maybe it can open up our brains and find a short-term solution would do. So because you don't know where AI will go, because this is this exponential growth that you can hardly measure and see where it's going. So that's why my last question included the last one, because maybe some people would wonder, okay, so it's a national level, then it's European Union level, so it's bureaucratic. How this impact me as a person, as a creator, or as a cultural operator? Because you also mentioned the other guys in the production field, not only the artist and the creator. So, but I think that if we can see the system and the network, we can have better ideas how to deal with it and to have proposals. So yeah.
No, and I very much appreciate the ability to talk to you with this, and I think from our perspective, it's clear, like the bigger you do, the higher level you try to tackle this, the more chance of success you have. So, and from my analysis, yes, some people think that the EU is very bureaucratic, but to some degree, that is sort of like the level where we have sort of like, I think, operate on a set of shared values and sort of like common agency, and something can get done. Obviously, like if you could do something on the global level, that would be even better. But like we don't have the structures, and so I think it is imperative that people think about, like, okay, how can we build a strong enough countervailing, or not countervailing, but like how can we organize us in a way that this imbalance of power is not as big as it is currently.
Thank you. I was thinking about justice in my mind, so you just replied to my word. Okay, thank you so much, Paul. I will also give some links near our conversation, so that our listeners can go further. Also, your AI Levy proposal, and yeah, hope to meet each other. Why not live in an offline format? Yes. Thank you so much.
Okay, thank you so much, and I hope this was useful. And
yes.
yeah, looking forward to meet you sometime.